Hello, this is Greg Giardino,
And I'm Alison Hall.
and this is It's Your Smarter Money. And today we're going to talk about when should you use a trust. We know there's a lot of confusion about trusts. Who can use them? Why would you use them? What are the taxable implications? So today we want to review with you a little bit more about trusts and when you might want to use them. So if you can, Alison, start us off and maybe tell our viewers a little bit more about trusts and how they work.
I'm on it. So let's start with the basics. What is a trust? A trust is an arrangement where one party holds the legal title to property or assets for the benefit of named beneficiaries. The party giving up ownership of the property is called the grantor. The party managing the property in a fiduciary capacity is the trustee. And the party for which the trust assets are being managed or held is the beneficiary. Now, depending on the type of trust, its purpose, it's possible there's going to be some overlap with those roles, especially while the grantor is alive. They can serve as the trustee and even be the primary beneficiary. But at some point, typically triggered by incapacity or death, there will be a successor trustee put in place to continue managing the trust assets for beneficiaries that are, not necessarily the grantor at that point. The trust agreement is going to outline everything. Who's the trustee now? Who's going to be the trustee when that person is no longer willing or able to serve? Who are the beneficiaries now or in the future? And how assets are to be invested, distributed, etc. A variety of different assets can be put into a trust: cash, stock, bonds, real estate, even life insurance. And you're probably wondering, why would someone go through the hassle of hiring an attorney, determining a plan of attack for a bunch of hypothetical scenarios, and then retitling all of their property or assets to be held in the name of the trust? And there are three reasons that come up all the time. The first is to keep assets out of probate, which is the legal process of settling an estate when someone dies. Probate is public, so you get a little bit of privacy with the trust, and depending on what state you live in, it can be very expensive and just very onerous. So having a trust in place to bypass that entire process can be super advantageous. The second reason is going to be control. One of the most common terms we see in at least family trusts is dictating what type of expenses and on what timeline beneficiaries can actually gain access to trust assets. This can be invaluable if beneficiaries are spendthrifts, or you have children or young adults that are going to inherit a lump sum, and they might just squander it because they don't know any better. And the last reason is protection, specifically from creditors and estate taxes. A trust can help shield from those financial issues if it is set up properly. Now, these are all different objectives, and so it may not come as a surprise that there are a lot of different types of trusts. I'm going to throw it to Greg so that he can dive into some of the high-level differences and pros and cons.
Thank you, Alison. So there's many different types of trusts that are out there, but we're going to focus on really two main types, and that is the revocable or living trust and also the irrevocable trust. So starting with the revocable trust, the reason why they call it a living trust is because the grantor, the person who contributes the property to the trust, can modify the terms of the trust while they're alive, hence living trust. So some of the pros to doing this, as Alison just spoke about, control is a big one, but it also bypasses probate. So whoever you name as your beneficiaries, it will go directly to them, and it's pretty quick and pretty efficient. And you can think of a revocable trust, a living trust, really as a will substitute. And one of the nice things of having a revocable trust is also the fact that it can avoid guardianship. So when might this come into play? Why would that be important? So for example, if you have let's call it a brokerage account, and you contributed that to a revocable trust, and for some reason you become incapacitated and you can't make decisions, you can't manage your assets in the trust any longer, well, you can name what's called a successor trustee. I know Alison mentioned that previously, but that's a way for someone to really step in and get immediate access. And that's important because guardianship can be really time consuming. In fact, it could take longer than probate in some instances, and it actually could be more expensive. We're talking tens of thousands of dollars to go through guardianship, which is where the probate proceedings need to appoint someone to manage that incapacitated person's affairs. So it's really important to keep in mind. So what are some of the drawbacks of having a revocable trust? Well, they don't reduce any taxes. What do you mean by that, Greg? Well, since the owner, the grantor, has complete control over the assets of the trust, there's no special benefits afforded. Any income, any gains, any losses will actually flow through the trust to the donor's tax rate. So there's no benefit there. Now, going to the irrevocable trust, in a way, it's almost the opposite of a revocable trust. And what we mean by that is, generally speaking, you can't change the trust agreement, the trust provisions. I mean, there's certain nuances to that, there's certain exceptions, but for general purposes, you really can't change the terms of the trust. Additionally, the trust can also maybe afford you with creditor protection as well as reducing estate taxes. Why? Because the trust is an entirely separate entity. In fact, when you set up an irrevocable trust, you usually create a separate EIN number to designate that it is in fact a separate entity. So it's not owned and controlled by the owner as you would see in a revocable trust. Now, what are some drawbacks to having this type of trust? Well, taxes can be a bit pricey. If there's any retained income in the trust, actually, if it's over $15,670, any additional income above that number will be taxed at a marginal tax rate of 37%. So that can be a deal breaker for some. And another interesting fact is you may not get what's called a step up in basis. So if the individual owner of the trust owns the trust assets, and if the trust assets
Do not.
then become included in that individual's gross estate, then they do not receive what's called a step up in basis. So that can be a huge deal and can cause a lot of taxation for your heirs that inherit an irrevocable trust. So you really have to carefully weigh the tax benefits and the additional benefits, whether it be creditor protection, whether it be reducing potentially estate taxes. You really have to weigh them with the appropriate tax and legal advisor when you look to set one of these things up. So with that being said, hopefully you learned a little bit more about how trusts work today, and maybe this will give you some good ideas on if it's even appropriate for you. But once again, if you have any questions, please reach out to our team. We'd be happy to work with you with the appropriate estate planner to make sure that you have a trust in place and that it serves the needs that you have. Until next time, see you soon. Take care.